Well, good day, everyone. Welcome to the godless government that was so wisely established in our United States Constitution. Well, hey, we've got the case of the drag queens for you today. Thought we would just point out a few highlights on this. You can see this decision is from January of 2019. And basically what we've got here is we've got a couple of our Christian friends, Tex Christopher and Pastor Calvin Miller, suing the library lady in Houston and also the mayor of Houston. And don't we all have better things to do with our time? Let's see what the lawsuit is about here, if this is something that we should really get so fired up about. First of all, spoiler alert, the Christians lose this case, and we'll just talk a little bit about how and why that happened. So the background here, the library first put this advertisement for drag queen Storytime on its website. And it just basically gave the time and place, a few details, and it said that the queens will help to instill a sense of love and acceptance in our children, etc. Let your imagination run wild. Well, our Christian friends were not going to have any of that. They object to the drag queens, they object to the LGBTQ community in general, and same-sex marriage. They complained to the library, and the library said, hey guys, we're just trying to give something that we think is important for the community and the culture, so we're going to keep doing it. Our Christian friends weren't going to have that, so they sued. They start off by saying, hey, we pay taxes in this community. We have library cards. We use the library. And basically what you're doing with this drag queen story time is that you are promoting your own religion with taxpayer money. What is that religion? Secular humanism. Our Christian friends have tried this before. This is just the most recent attempt. The allegation here is, hey, why should your religion win? Christians wouldn't be able to do their own story time down there. Why should the secular humanists? And they claim that this is actually advancing a religion, this secular humanism. So they asked the judge to stop it right away. And the judge said, no, we're not going to do that while the case is pending, maybe at the end, but we're not going to do that while the case is pending here. The court talks a little bit about legal standards. We won't spend too much time on that. Basically, the court has to have some legal power to make a decision. That's what the first standard says. And the next one here is that the plaintiffs have to also really establish some facts that will show that they are entitled to relief. And as we're going to see here, they kind of failed to do that. And they lack what's called standing in legal terms. And that is that they must have an injury in fact. Okay, they have to actually be suffering some kind of concrete, actual injury here, and not something that is just conjectural or hypothetical. And our Christian friends are going to have a problem with that. Now, they do claim that, hey, we are definitely suffering here because they're using our library money. We have library cards, we pay taxes. We are also offended by this drag queen story time thing that you've got going on. But instead of really pointing out how they're going to be injured, this is interesting here, this language, they rely on imagined dire consequences to other and not an actual injury to themselves. This is what the library's version of things are. So the court goes on to talk a little bit about religious display and religious exercise cases. And they give an example here, a couple of them. One is that sometimes you need very little to show that there is some kind of standing, some real controversy. Sometimes just getting an electric bill showing the cross symbol is enough to get you into federal court. And other times when you're just complaining about something that's kind of imaginary and abstract, that's not going to be enough. And they give an example here. There was another case where some students and their parents were complaining about alleged immorality with some kind of reading event, and the courts just were not going to let that clog up their docket. Also, another problem for them here is their Christian friends were so offended and afraid they did not even witness this event or come in contact with this in any way. Apparently they saw advertisement for it on the website and that was it. The court said they have to have proof in the record that they were actually exposed to the event, and the plaintiffs admitted that it was so bad they couldn't even go down to the library. If there are any injuries in a case like this, the plaintiffs have to show that the library in this case actually did something to them, and that if they win the case, there is going to be some redress, some remedy that will actually fix that situation. The court here said, they really don't meet this criteria because they're also complaining about same-sex marriage, also public demonstrations by the LGBTQ people, and what they're really doing, it's to the bottom of it down here, the plaintiffs are using the case to protest gay right movements and other federal rights that have been conveyed on them by the courts. So it's not that they're actually suffering some kind of injury here. They didn't even go down to the library to see this stuff going on. They're just kind of using this as some pretense to get into federal court. Also, I think this is some interesting language here. The plaintiffs lack standing because eliminating drag queen Storytime will not cure their perceived feelings of persecution. And that's what the case was really about. Christian friends were feeling persecuted, and simply feeling persecuted that's not a legal matter, at least not in the federal courts. They talk a little bit more about taxpayer standing. They said, hey, we pay taxes here, we've got library cards, you can read this on your own if it's of interest to you. And basically what the judge says about that is, look, the library has a budget of $40 million. You're talking about, the library buying a couple of books and putting out some promotion. That's a very small amount of money. So with such a minimal actual financial impact on anybody here, we're not going to make this about money and how the state can or cannot spend its money. So the issue starts to come down to this matter of secular humanism, whether it is an alleged religion. The library basically says, look, our religious friends are basically saying, we have a religion going down here, secular humanism, but secular humanism is not a religion. They briefly talk about the Levin test, which you can read on your own. And they basically say that the Levin test does not really apply here because we're not even talking about religion at all. Here's the case that I was mentioning earlier about the supplemental reading program, talking about supernatural beings, wizards, sorcerers. Apparently, there were some Christian parents complaining about, sounds like Harry Potter or something like that. And the court in that case said, look, this hardly sounds like the establishment of a coherent religion. We're simply reading some fictional stories, talking about fictional bad guys. This is not religion here, guys. And in the same way, the court here says the plaintiffs failed to allege any facts or basis showing that this drag queen story time is a religious activity. Basically, they're just sitting around reading these fictional books to these kids, and we don't even have to get into what kind of religion, whether religion is permissible or not, because it's not even a religious activity that we're talking about here. It's also interesting here, our religious friends are talking about the library using tax money to brainwash the children. And I think it's really interesting that our Christian friends would complain about someone else doing brainwashing. There's more than a hint of irony there if you want to read into this case a little bit more and see what some of the details are. So basically, the court concludes that the court just has no business getting involved in this. There's not even really a religious claim here, so the parties are going to have to figure this out on their own. It's an interesting case. In this particular case, we have the Christian folks on the offense. They are usually more on the defensive side of things, with atheists or secular folks complaining about how religion is encroaching upon various aspects of government or public life. And so it is interesting to see the Christians on this end of it for a change. And the court just does not, in this case, did not look very favorably upon that. If you have any questions, please let me know. Be happy to discuss this with you more. Thanks a lot.